Hi everyone, and welcome to this panel discussion in which we're going to look at and discuss the future of dispute resolution, which is one of the sessions forming part of Osborne Clarke's wider Dispute Week. So during this session, we're going to look specifically at how you can learn lessons from past disputes and take these lessons into future disputes. We're also going to discuss some practical tips on managing individual and portfolio disputes. So when a business is faced with a dispute or a number of disputes across a portfolio of projects, it's important for the success of that business that not only are the disputes managed effectively and efficiently in the moment, but also that lessons from those disputes are captured and then disseminated across the business. This helps minimise risk and manage disputes going forward for that business. So in this session, we're going to look at the legal technology that's available to assist with more efficient and cost-effective management of disputes, as well as practical guidance, hints and tips, and some war stories from our experience of managing individual disputes, as well as portfolio disputes across a number of dispute resolution processes in a changing disputes landscape. So I'm Emily van Schalkwyk. I'm one of the partners in the real estate disputes team at Osborne Clarke. And today for this session, I'm joined by Rebecca Francis, an associate director, also in the real estate disputes team, Danielle Griffiths, an associate director in our construction disputes team, and Daniel Harrison, an associate director in our commercial disputes team. So looking first at lessons learned, Danielle, can you tell us about how a business could approach a lessons learned exercise at the end of a dispute?
Yeah, of course. So I think the step that's quite often missed at the end of a dispute is reflecting on those lessons learned. And I think this is understandable as parties are either pleased with the outcome, relieved the dispute is over, or generally want to forget the result. However, not going through that process is a missed opportunity to de-risk future projects and also any future disputes. So I think at the end of any form of dispute process, time should be taken to consider what went well and why it went well, what didn't work well and why, and the lessons that arise out of those issues. It's then important to make sure those lessons are actioned, and whether that's amending the terms of your contract to address an issue of interpretation that's arisen, or delivering training on privilege and what documents should or shouldn't be produced in the context of a dispute for your broader team, or any other specific actions that might arise out of the dispute that the business has been involved in. And ideally, a process would be agreed with your external or internal lawyers as to how these lessons are captured and then disseminated from the outset of a matter. So they can be captured as the matter progressed and are not forgotten when you get to the conclusion. So, for example, this might take the form of a report, which can be populated with successes and issues as the matter progresses, followed by a discussion or workshop at the end of the matter, and then, most importantly, ongoing tracking of actions until those actions are completed.
Thank you. And what about managing portfolio litigation? What kind of tools are there available in those circumstances to help with that?
So, where a business is, as a matter of course, subject to a large number of disputes, or is managing disputes across a broad portfolio of matters, and we see that particularly in construction and the property industries, for example, technology can greatly assist in managing existing and future disputes, and also identifying patterns or lessons from those disputes. So, for example, Osborne Clarke Solutions can develop platforms for clients to track and manage individual or portfolio wide disputes. And these platforms can help identify trends. So this might include areas of a business that are seeing more or less claims than others, and that allows a business to investigate why that's happening and what can be done about it. And also to help identify trends as to the types of dispute a business is getting involved in. And again, this gives the opportunity for a more detailed investigation as to why particular disputes are occurring at any given point in time. And from a claims management perspective, technology can also help track the value of those disputes and therefore any likely recovery for the business or any potential exposure that the business faces, as well as the cost of those disputes to the business overall. And reports on any of these metrics can be run whenever required for distributing amongst the business and amongst whatever groups are needed.
Thanks, Danielle. That's really helpful. So now looking at how the litigation and arbitration landscapes are changing and how that might impact on claims and how they're ran and defended moving forward. Rebecca, focusing first on the courts, can you tell us how the litigation landscape is changing and what impact that will have on clients running and defending claims moving forward?
Sure. So I think firstly, it is important to flag that there is quite a disparity across the spectrum of courts. So whether that be at the first instance tribunals or county courts, or whether your dispute is in the High Court, and then as you work up chain, depending on where your dispute fits, will often dictate what tools you can deploy to manage your claim or portfolio of claims. And we may see change deployed at different rates across the courts. And obviously, this is balancing the need for speed and cost efficiency with access to justice. And I do think it's important to say that obviously with COVID, everything went online, but it's certainly not the case that everything has remained online. So definitely have to keep that in mind. And really in that context, in terms of how the litigation landscape is changing, Sir Geoffrey Voss, who's the Master of the Rolls, gave a really interesting speech last year, setting out his vision for the future of disputes resolution in England and Wales. And he's in the process of setting up what he calls a funnel with 3 layers, starting with a website and an app, signposting claimants to pre-action protocols and encouraging settlement, and then moving to an online justice process in order to resolve claims. So there's a big focus on moving away from a paper-based process, which obviously will be welcomed by the majority. I think wider than this, though, is a recognition that new technologies will lead to different types of disputes as well. It suggested that disputes in say 20 years' time are unlikely to revolve around facts of matters as many do now, as almost everything individuals and companies will do will be recorded, and payment systems will be using crypto assets and using blockchain. So there'll be arguably a lot less sort of likelihood of disputes around the actual facts of matters. Litigants will want increasingly fast justice. And again, Sir Geoffrey Voss was saying how this may turn, this in turn will require more AI-led decision making, particularly for bulk claims, but provided always that there's always a right to appeal to a human judge, so that won't be lost. And then a further major issue that was sort of identified is really how countries will deal with borderless disputes, such as those involving blockchain, and really how the current principles of conflict of laws are unlikely to be fit for purpose to resolve such disputes. And there will be an expectation on national courts to work much closer and more efficiently together in order to resolve the issues. And I think lastly, the sort of big thing to flag in terms of the changing litigation landscape is how mandatory mediation is looking ever more likely, with really stringent cost consequences for parties who refuse to mediate. So you just won't be able to get away with saying that, you know, mediation just isn't going to work, or it isn't relevant, even if that might seem legitimate. So parties really do have to be alive to this as part of their dispute resolution strategy.
Thanks, Rebecca. So that leads really nicely onto arbitration and what's going on in the arbitration world. Daniel, how has the arbitration landscape changed, and what impact will that have on clients moving forward?
Thanks, Emily. So it's helpful to talk about this from a practical perspective first, and then in terms of substance. On the practical side, a lot has changed in the running of arbitrations in the past few years, and the real question is what changes are here to stay. The international nature of arbitration, with parties, counsel, arbitrators, witnesses, and experts often located in different jurisdictions around the world, has meant that some of the changes brought about by COVID, including remote hearings, have remained for longer in arbitration than in the courts. Now that travel has, in most cases, returned to normal, there are other reasons why clients are continuing to opt for remote hearings. These include not only significantly reduced costs, but also a reduced environmental impact. That's consistent also with a push from practitioners for green arbitration. Another part of this is that where hard copy filings were once the norm, they are now the exception. And I've even seen parties push back on requests from arbitrators for hard copies. In terms of substantive points, the biggest news for clients is that London remains a very attractive choice for arbitration, as a result of some things changing and some things remaining the same. The Law Commission has completed a consultation on proposed changes to the Arbitration Act, which was enacted more than 25 years ago. The ways in which the Law Commission proposed that the Arbitration Act might change and the ways in which it proposed that it might stay the same are designed to ensure that London remains one of the world's most popular seats for arbitration. There is a clear intention that the Arbitration Act should retain key advantages for users of arbitration, such as confidentiality. There had been some questions around this, given a push for greater transparency from some quarters in recent years. There are also proposals introducing certain points which did not exist, at least expressly, in the Arbitration Act, but in some instances did already exist in the rules of arbitral institutions. One example is the introduction of provisions for summary dismissal in arbitration, which will be important for some clients. Arbitration has not changed, at least not for the worse, due to Brexit. This is, as practitioners like to say, because arbitration in England is Brexit-proof. What this means is that both the running of arbitral proceedings and the enforcement of arbitral awards are unaffected by Brexit. Lastly, it's worth noting that London as an arbitral seat is positioning itself well to deal with issues which we expect to arise more and more in the future. A great example of this is the introduction of the digital dispute resolution rules, which aim to facilitate dispute resolution with regards to digital technologies and assets such as crypto and smart contracts.
Thanks very much, Daniel. And thanks more generally, Rebecca and Danielle, for helping with this session today. And thank you all for watching. If you did have any questions at all on any of the points raised during this session, please do get in touch with any member of the team and we'll be happy to come back to you. Thank you.